Welcome to Chapter 6, Introduction to Criminal Justice, Law Enforcement in the Criminal Justice System. Principal Decision Points. The three principal decision points of the criminal justice system occur in the law enforcement segment of the process. The detection of crime, working rules versus street sense. The investigation steps include the search, probable cause, exclusionary rule, interrogation, and good faith exception. There are, of course, other investigatory practices. And the arrest would be the final decision point. The detection of crime. Detection is the discovery of crime or probable crime by the police. There are working rules, which are guidelines for behavior that identify the circumstances that justify different police actions. Self-fulfilling prophecy. An example of this would be an officer who focused on people or things that were out of place. Street sense describes the ability of experienced police officers to know who is likely to be a criminal or dangerous. While this is a somewhat useful tool, a street sense could invite in certain biases when police officers feel as if they know something. The investigation stage. Investigation is a process that continues throughout the law enforcement segment of the criminal justice system. It is the accumulation of information and evidence that links a particular person or group of persons to a crime or set of crimes. The investigation has two decisions. One, whether to investigate a suspected crime, and two, how to best proceed with the investigation if one is initiated. Search. The search involves the seeking out of evidence of a crime or location of a suspect. Searches can be conducted only on the issuance of a warrant based on probable cause. Probable cause is evidence that leads a reasonable person to conclude that a crime has occurred. It's very important to remember that threshold called probable cause. And it's also important to point out that it specifically states a reasonable person. The exclusionary rule, also a very important point, states that police cannot use illegally or improperly obtained evidence in trial. This process was applied to the states in the case of Mapp versus Ohio. The key point with Mapp versus Ohio is that the exclusionary rule, meaning that tainted evidence obtained without a warrant or probable cause, could not be applied in court. However, Mapp, to be very specific, applied this rule to the states. It was already an existing rule for federal agencies and federal law enforcement before Mapp versus Ohio. The frisk is a very important term. The frisk is a traditional police practice that the Supreme Court has upheld when conducted under specific circumstances. In Floyd versus New York in 2013, the practice was rejected by the New York City's police department's stop and frisk policy, calling it a form of indirect racial profiling. Stop and frisk would mean that when a police officer feels that there's a reason that a crime could occur, they can stop, detain, and frisk. Now, this does not include, frisk is not a search of someone's pocket or their coat or jacket. A frisk is an outside pat down, and the only thing the police officers are supposed to be looking for in a frisk would be a gun. And it is really established in order to help keep the police safe. Search incident to a lawful arrest occurs when the police officer arrests someone and can search only the area immediately in the reach or control of the suspect. So under a search incident to a lawful arrest, if someone is arrested and they're a passenger in your vehicle, theoretically the police could not search the trunk of that vehicle under a search incident to a lawful arrest because this person sitting in your passenger seat could not reach the trunk or maybe even the back seat. Only what that person could reach can be searched. A hot pursuit is an exception to the warrant requirement that allows officers to follow and search for a suspect in a pursuit. So if you're chasing someone and you're in hot pursuit, this doesn't mean that they're 3 or 4 miles ahead of you. It means they're directly in front of you. And if you are chasing that person, you may enter their home without a warrant in order to obtain them. Consent search. In a consent search, the suspect consents to the search, so any evidence found is admissible. Some states and courts have ruled that it needs to be in writing, that you have to have this person sign it. Some departments' policies could say that the person has to sign or waive their Fourth Amendment rights to allow you to search them. Others, if it's verbal, it's fine. Automobile searches entitle officers to conduct a full search of an automobile that has been legitimately stopped by officers, but you can only do this with probable cause, meaning that an experienced officer has reason to believe, based on various circumstances, that a crime has been committed, or that some sort of illegal evidence could be found. An inventory search differs in that it allows the police to obtain an automobile or items from an individual to search the contents for inventory. So if someone's arrested and they're in their vehicle, the police then have control of that vehicle, and they're responsible for any sort of items that are left in it. So if you're a police officer, you don't want to leave it unlocked. Once you've arrested them, if someone breaks into that vehicle, steals something from it, it's going to be on you. So the courts have allowed inventory searches for the police to say, okay, I've arrested them, and now I'm going to have their vehicle towed. I have to see what's in it. And is there money in the back? Is there medicine or personal items that are in there? Now, while the police are conducting that inventory search, which is not a criminal search, they're looking and simply inventorying and making a list of what's in that vehicle. If they were to come across items that are illegal, then of course it's going to be admissible. They were not conducting a criminal search. They were just doing an inventory, but then they happened upon these items. The plain view doctrine does not pertain to a type of search. If an officer sees criminal evidence in plain view, he or she may seize that evidence. So just think about what the general public can see. If the general public is standing in a Walmart parking lot and happens to look in a vehicle and see something that's illegal, or say a dead body in the back seat, then if the police are standing there and they have a right to be there to look inside the window and see it, that's plain view. They can seize that item. Cold case squads are teams of detectives dedicated to pursuing unsolved cases lacking significant leads. They most often select cases where new witnesses have come forward with evidence, when new DNA evidence becomes available, or when new DNA technology becomes available to test old evidence. An interrogation. I think it's important to mention that an interrogation differs from an interview. So police conduct interviews all the time. When you're conducting an interview, the person is free to go. When you're conducting an interrogation, most of the time that person is considered to be detained. So an interrogation is a search for evidence through seeking testimony or responses to questions put to the suspect. The Fifth Amendment protects citizens from overzealous interrogation by the police. You cannot be forced to incriminate yourself under the Fifth Amendment to the Constitution. Most of us have heard of the Miranda warnings, but it's important to know the case and the year. So Miranda versus Arizona in 1966 is perhaps the most famous of the court's exclusionary rule cases. Only 1% of police chiefs nationwide believe that too many offenders get off easy as a result of the Miranda warnings. The outcome of the Miranda ruling has been a proliferation of more professional and effective police officers. We all know what these Miranda warnings are. You have the right to remain silent. You have the right to an attorney. You hear them on television. The police have to read these rights before conducting an interrogation. So I've had people, when I ask them, when I've arrested people in the past, people will tell me, I'm not going to go to jail over this because you arrested me and you didn't read me my Miranda warnings. And I would always respond with, but I didn't ask you any questions. If I see someone commit a crime, I don't need to ask them if they committed it. I saw them do it. So a lot of times I would just make the arrest, and people would feel like that if I didn't read their Miranda warnings and tell them that they had the right to remain silent and the right to an attorney and that one could be present before any questioning, they would assume that that's going to be thrown out of court. When in fact, the only part of it that would be thrown out of court would be their responses to my questions. Therefore, if I don't ask them questions, I don't have to read Miranda. That's only before questioning during a custodial interrogation. There have been a lot of anti-Miranda warnings practices that the police have engaged in. The modern interrogation process, as defined by Davis in 2008, you can read about that in the text. The interrogator works to pressure the suspect into talking. They can be motivated to confess, either by increasing stress and discomfort to motivate confession as a method of escaping the situation, or leading the suspect to the rational conclusion that confessing is in his or her best interest. It is important to note that Miranda warnings are only necessary whenever there is a custodial interrogation. This occurs whenever a suspect is under arrest and being interrogated by officers. I'm going to put a caveat on that. You don't have to be physically under arrest formally to where it's a good idea to read the Miranda warnings. And as a best practice, I would mention as a retired police officer that most of the time new recruits and people who are taking criminal justice in college will say, how am I ever going to know when I should read Miranda or when I shouldn't? When's the best time to read it? Or, and my response has always been to new recruits is, when in doubt, read it. We should err on the side of caution and be respectful of people's due process rights. So there's nothing, just because I mentioned in this presentation that I didn't have to read Miranda, there's nothing to say that I shouldn't or that I can't. So you could always read Miranda anytime you want. There is a good faith exception to the exclusionary rule. If the police conduct a search believing in good faith that the search is permissible, then the evidence can be used at trial, making a good faith exceptions. And there are three different cases I want you to know. It's Katz and U.S. versus Leon, and then Utah versus Strife in 2016. You can read about those in the text. But a good faith exception would mean that, for instance, if a police officer is given false information, but the police officer believes that it's true and then obtains a search warrant, then that's going to be a good search warrant because the police had no reason to believe the person was lying to them. That's something out of the police's control. The police were working in good faith, doing the best that they could at the time. The courts are not automatically going to exclude that evidence just because it was based on a lie. But if the police had a reason to believe the person was untrustworthy, that would certainly change the circumstances of the confession or the search. Other investigatory practices. Forensic science, a very popular course at some colleges. Combined DNA indexed system, the CODIS, serves as a database allowing for comparisons between crime scene DNA samples and existing profiles of convicted offenders. So you may ask, how does the DNA CODIS actually get those DNA samples? It's called a buccal swab, and it looks kind of like a Q-tip. And a certain amount of crimes require by law, especially in Virginia, that you swab someone's interior of their mouth and then send it in to DNA. So if you're, for instance, if you're even charged, so this wouldn't even be someone who's convicted. If you are charged or arrested for most felonies, especially violent felonies, when that officer is processing the person they arrested at the magistrate's office, so we take them in, then they're able to see a magistrate and determine whether or not they're going to spend the night in jail or get a bond. We would fingerprint, and then the buccal swab would come along as well. So we would swab that. They're required to give up that, and then it goes into a database after that. Identification techniques, throwdowns and lineups. A throwdown is having witnesses examine photographs to determine if they recognize this person. Of course, we all know what a lineup is, and that's having witnesses observe possible offenders. Surveillance. The bulk of surveillance conducted by police agencies is physical surveillance. So contrary to what you see on television, that the police have a way of just pulling or hacking into video monitoring systems or cell phone data. That's not always true. Most of it, if the police are going to conduct surveillance, they just have to sit and watch it the old-fashioned way. Informants and crackdowns. Informants are another investigation tool used by the police. They're extremely useful to police in intelligence gathering, but neither criminals nor the police respect the informant. They do not make particularly good witnesses. In crackdowns, police devote increased attention and resources to either specific types of crimes or to crime in particular places. They reduce crime in the short run, yet they are expensive out of the ordinary and attract attention. Undercover operations. Almost every major police department has a vice unit comprised of officers who attempt to uncover instances of victimless crime. When we're talking about vice, we're talking about things that are illegal, but also would fall under the realm of what most of society would determine to be moral crimes as well. So a vice unit would likely work on drugs. They would work on prostitution rings, things like that. They pose as either potential customers or potential providers of illicit goods and services. A good example of that would be an undercover officer who would drive in an area and see if he's approached by a prostitute. That's a good example of a crackdown as well as an undercover operation. A sting operation is a form of undercover operation in which the police present an opportunity for offenders to commit a crime. So the opposite side of that could be a female or male police officer who would pose as a prostitute and then see if they are approached. So they're not really going to go up and solicit crime, just be in an area that's a high crime area and see as part of a sting operation. The sting operation gets its name from the slang of confidence artist. The taking of the victim's money is the sting, for example, with the con artist. Police departments conduct sting operations often use deception techniques such as disguises, fake storefronts, false advertising, or decoy cars to bait the offenders into committing crime. There could be plenty of debates in an ethics course over whether or not the police should be engaging in this behavior. Most people would find some of it difficult to swallow when it comes to the police lying, but at the same time, most people want to see their community remain safe as well. The entrapment defense to criminal charges is applicable when the entrapped offender did not have the inclination to commit a crime, absent police enticement. So let's go back to the example of the police officer posing as a prostitute. If that person posed as a prostitute and then went up to people who were simply walking down the street and then asked them for money for sexual favors, that would be the entrapment. But if the police officer is disguised as a prostitute and simply standing there and is approached by someone who is looking for a prostitute, that would not fall under the entrapment defense. The arrest. Arrest is the act of taking a person into custody. The decision not to arrest has been labeled as non-invocation, discretion. Discretion not to invoke the law. The police have that discretion in most instances in America to not make that arrest. As a matter of fact, there are very few acts that require an arrest. In Virginia, I can only think of one, and that would be that the Code of Virginia specifically states that an officer who responds to a domestic violence situation, and that officer can establish that there's a domestic relationship, meaning that they're related or somehow through marriage or live with that person, if the police officer can determine the primary aggressor, then they have to make that arrest. But in most cases, there's no repercussions. Now, a police officer may be exposed to some sanction from their agency if they refuse to make that arrest, but that does not necessarily mean that they're legally required to do so. Invocation discretion occurs when the officer decides to make an arrest. Occasionally, an officer will opt to enforce the law when the rule of thumb would suggest non-invocation. Example could be tolerance limits regarding excessive speed. So police officers typically set their own tolerance rates for speed. That could be decided amongst their patrol group, their shift, their county, their agency. Sometimes officers can set that on their own. For example, most officers that I know will give people 10 miles an hour. Some may only give you 5, but most will give you 10, 11, or 12 miles an hour. So that means that officer is choosing to ignore everyone who is breaking the law under that speed. Booking is the official public recording of an arrest. and seeks to prevent the police from holding an offender incommunicado. So booking would also be where that fingerprinting, taking before the magistrate, and also the buccal swab if required, which is not always required in many misdemeanor cases. Due process, crime control, and the police. Tension exists between due process and crime control and policing. So kind of think of it, if you look at a picture of Lady Justice, a lot of times there's a scale that is representative of the criminal justice system, and that's what's supposed to be on both sides of that scale. That would be due process on one side and crime control on the other. And as one gets overloaded, then the other one is going to have less of an impact. So if we focus too much on due process, that means people's rights, which is great that we're focused on those things. But if we put an overemphasis on that, then you're probably going to see crime spiral out of control to some degree. And if we put too much of an emphasis on crime control, then the police are likely to violate due process. So it's finding that balance that's very important. Examples include the reactive style of policing, the exclusionary rule. The good faith exception actually represents the balancing act of that characteristic, all of the American system of criminal justice. The negative opinion of the police can affect the suspect's demeanor in subsequent encounters with the police. Police misconduct gets a lot of attention in today's society. Actions that can be considered misconduct range from improper treatment of citizens, or that's excessive force and harassment, to the violation of internal department rules, abuse of sick time, driving the department's car recklessly, etc. One of the most notable forms of misconduct is corruption. A combination of power and lack of accountability makes corruption possible. Corruption is difficult to define. Withrow and Daly in 2004 suggested that corruption lies on a continuum that includes lawful activity. Police behavior is corrupt when the officer comes to expect or demand special treatment or reward. So a lot of ethics classes, what they'll start to talk about, whether it be in the police academy or in your college curriculum, would be to start with things like free meals. Is it okay if a police officer takes a free meal? I've had my students over the years give me various examples of, well, I think it's okay, or no, I don't think that's good. But these two researchers in 2004 would talk about it's not necessarily illegal for a police officer to take half off their meal or to take a full one, but is it really a good idea, or is it a slippery slope that could lead to other things? Okay, what if someone said free meals in this restaurant, but you have to come by my storefront or my restaurant, 2 or 3 times a day in order to get this free meal? Well, that sounds okay because that police officer in that community is responsible for protection of that restaurant. However, are they disregarding the other restaurants in the community and only giving special police attention to the ones that give them free meals? Misconduct most often occurs among new officers, while gradually decreasing over the course of an officer's career. It could be that the people will wash out who are more apt to engage in misconduct. It also could be that some new officers learn that there's certain things that you don't do in order to stay in the career and retire. Nearly 40% of officers involved in sexual misconduct investigations are repeat offenders. Police misconduct represents a failure within the organization as well as the individual. Departments which enact policies that increase officer stress or are viewed by officers as unfair may have more problems with misconduct. Use of force. Citizens fear the unbridled use of force by the police. Of course they do, but it is not unbridled, or it should not be unbridled use of force. Use of force, the power to use force, is given to the police in America by the citizens, and it has to be used respectfully. Approximately 10% of officers are assaulted or killed each year. That's a high number, I know that it looks like, but we're also including police assaults in there, not necessarily officers who were shot. Many believe police officers should be allowed to use force to gain compliance from resisting suspects or to prevent the escape of dangerous offenders. In other words, a lot of people think if someone is running from the police should be able to shoot them in the back. There's plenty, as you go throughout your criminal justice career or throughout your college career and start to take classes in criminal procedure or criminal law, you'll read about the case of Tennessee versus Garner, which says you cannot shoot or fire upon a fleeing felon unless they're going to hurt someone else. So there's a lot of caveats to that statement, but most people believe that the police should be able to do that. Many people believe police officers should be allowed to use force to gain compliance. In other words, when you tell someone, put your hands behind the back, can you use force to make them do it if they refuse? Questions arise, however, when a police officer strikes an offender too many times, or when an officer shoots or kills an innocent or unarmed person. Again, think about Lady Justice, think about those scales. The more power we give the police, the less the due process is typically followed. Less than 2% of those who have contact with the police experience the threat or use of force. Amount of force usually ranges from verbal commands to physical force, such as grabbing, using pepper spray, or pointing their service gun at the suspect. So even though you don't fire the weapon, most agencies would consider pointing a weapon at someone to be a use of force. Police use of force is also linked to the level of violent crime in a community. About 75% of those subject to verbal or physical force later describe the police actions as excessive. Fears of excessive police force are particularly clear in cases where the officer used deadly force. Those are the ones that get the most attention. You can think about the Rodney King incident in the early 1990s, Michael Brown, and then Eric Gardner. African Americans are subjected to police assaults disproportionately. That's data, that's not an opinion, that's known. Ultimately, implicit biases and spur-of-the-moment decisions from police officers and citizens during an encounter could contribute to increased use of force. Community relations. Community relations is a long-standing issue that has received much attention in recent years. Less than 25% of U.S. residents aged 16 or older have a face-to-face contact with the police in a given year. So only 1 out of 4 over the age of 16 even have a contact or a conversation. Therefore, much of one's perception of the police is a result of friends or family members who may have had contact with the police or the media portrayal of the police activities. So we certainly start to see on TikTok and on Facebook and on Twitter, everyone has a phone now. So everything's being recorded, and they're typically not posting videos of the police having a quiet, calm interaction, even though that is the vast majority of interactions that the police have with people in America. But those do not get likes, those do not get hits. People don't want to post that. They only want to post the negative. And so it's certainly changing people's mind and their perception of the police in a very negative way and unfair way as well. The movement to community-oriented policing sought to increase the role of citizens in setting police policy. The police work with the community to identify problems and select solutions. Many police departments which focus on community-oriented tactics have been able to enjoy higher levels of community support. And when they're able to get those higher levels of community support, they're also probably going to see much less use of force, much less stress on the police as well. Police crime control. Crime control has been considered an impossible mandate for police. Police do not define what behaviors are criminal, do not control their own budget, and do not control the social and psychological factors that lead individuals to commit crimes. So if the police have a job, and that is to catch criminals, right, to apprehend, you really can't control the business that comes to you. But there have been a lot of conversations on whether or not the police need to be more proactive in their communities to stop crime before it happens. One of the issues would be that employment rates, right? Personal strain on people's relationships causes crime to go up. That's something the police cannot and will never be able to control, is employment, right, or the economy. Yet they are still responsible for controlling and preventing crime. Procedural justice suggests that people oppose rules when they believe their treatment is unfair. If people believe they are simply the targets of police enforcement and that the police are not concerned about their welfare, they may begin to question the legitimacy of the police and of the law more generally.